Namaste. So now we'll write an answer, or rather write down the pointers for an answer for constitutional interpretation and amendment. So first and foremost, we're going to be focusing on the interpretation bit, and then we're going to trace out the most important amendment, basically using 368. All right. Now write this down. In democratic countries, the judiciary is given a place of great significance. Primarily, court constitute a dispute solving or rather resolving mechanism between citizens and states, among various organs of the state itself. So we're talking about interpretation of the constitution. Keep that in mind. So these are, you can say, these are pointers that will go in your model answer. So I want you to prepare an answer beforehand for the interpretation of the constitution. First and foremost, we go in for doctrine of judicial review. Now, constitution is the supreme court of the land, or rather supreme law of the land, sorry, and any law inconsistent with that is void, as it's given in Article 13. Primarily, the doctrine of judicial review is contained in Article 13 primarily, but in other articles as well. So in UK, the courts interpret laws and there is no constitution, because not the constitution, the court अब आप कॉन्स्टिट्यूशन को कैसे इंटरप्रेट करेंगे, बिकॉज इन द यूनाइटेड किंगडम देयर इज नो रिटन कॉन्स्टिट्यूशन देयर, बट इन कंट्रीज विद द रिटन कॉन्स्टिट्यूशन the courts have to interpret the constitution, the written constitution that is, but we have to change the interpretation as you can say the time moves on, the timeline moves on. We have to keep on updating our interpretation style. The courts thus act as the supreme interpreter, protector, and guardian of the supremacy of the constitution by keeping all authorities, legislative, executive, judicial, quasi-judicial, within legal bounds using the constitution. Right. So the Supreme Court is acting supreme because it's keeping everyone in check. That is why it's known as the Supreme Court. The task of interpreting the constitution is a highly creative judicial function. So when you interpret the constitution, the words that are written there, that doesn't mean that that you have to stick primarily to the word that is given, but we'll have to go into the essence of the word, such as by using doctrines such as pith and substance, eclipse, severability, etc., etc. So written letters, so you have to go in as per what the Bare Act is saying. You have to add on the values of the democratic society, and then you have to add on the individual liberty, the human dignity, and the rule of law. And when you mix all of this together, you get a good interpretation of the constitution. And of course, one more factor is the times that we live in. So for example, let us say a right to internet is not mentioned anywhere, but we can interpret Article 21 as having that right. Right to public health is not mentioned in 21, but we can say that it is, well, it is inherent in 21. So when we are talking about interpretation of the constitution, that is what we mean. So for example, the word void in Article 13 is just not void as per the English definition. It's a very different meaning, as you have seen in the doctrine of eclipse. We're going to discuss that. Because words remain the same, but their significance changes from time to time. ये sentence आप अपने answer में लिखेंगे ही लिखेंगे. That is the interpretation of the constitution. So two primary functions that it serves is legitimizes government action and to protect the constitution against any undue encroachment by the government. This process, in that you are interpreting words as per the times that we are living in, the individual liberty, human dignity, first and foremost, it will legitimize any government action, as in if the government is doing anything and the Supreme Court allows it, legitimizes. But it also protects the constitution against any undue encroachment by the government, that is exploitation by this government. All right. Now, Mr. Dowling, a legal scholar, used to say or said about the United States Supreme Court, the study of constitutional law may be described in general terms as a study of judicial review in action. All right. So this is his statement. If you can quote it in your answer, great. All right. And where did this doctrine of judicial review flow out from? That's Marbury versus Madison 1803. बहुत ही क्रूशल केस लो है. जब भी आप जुडिशियल रिव्यू के बारे में लिखेंगे, Marbury versus Madison cannot be skipped at all. It has to be mentioned in your answer. All right. So the United States Supreme Court claimed it had the power of judicial review, even though it wasn't explicitly given, but they claimed it. So because they could review आपके the acts passed by the Congress there. Now, direct judicial review, it annuls the executive. Indirect judicial review is interprets an act in such a manner that it comes within the ambit of constitutionality. तो judicial review में आप दो type करेंगे, direct judicial review and indirect judicial review. Now, judicial review में आप constitution versus legislative statute, let us say लड़ाई हो रही है and both are at odds with each other. The constitution wins each time, every time, because the other statute, the legislative statute that is being created by a process of parliament, it has to comply with this constitution. It can never ever override it, and to see over this fight is what we call as judicial review. ठीक है जी. Now you can trace this doctrine back to Marbury versus Madison and the natural law doctrine, that is man-made law was susceptible to correction and invalidation by reference to a higher law. That is what constitution versus legislative statute is. Alright, so judicial review is basically आपका the majority minority conflict. Also it covers out कि भाई what does majority want and how do we protect the rights of the minorities inherent to judicial review. Now, to interpret, expound and enforce the constitution, because it is not a self-executing document. Alright, so without the court, so what is the role of the court? That it will interpret, expound and enforce the constitution. क्योंकि कॉन्स्टिट्यूशन अपने आप तो इम्प्लीमेंट नहीं कर पाएंगे ना, अपने आप एग्जीक्यूट कैसे कराएंगे, बिकॉज इट्स मेयरली अ पेपर इन द एब्सेंस ऑफ द कोर्ट, राइट. सो आपके फंडामेंटल राइट्स, अदरवाइज दे आर जस्ट प्लैट्यूड्स. What does the mean? What is the word platitudes means? Platitudes बोल दिया मैंने, platitudes. So just general active passive, general describing statement. If the Supreme Court, for example, the Supreme Court of India vanishes, how do you exactly ensure that you have fundamental rights? You just cannot. So without the Supreme Court, fundamental rights are just platitudes. Alright. Now judicial review serves as a necessary check on the possible excesses by the legislature and the executive. कृपया करके ये लाइनें अगर आप लिखना चाहें, मतलब लिखना चाहें क्या लिखेंगे, but answers में do mention, because these are very well framed, basically you can say language for an answer. Now judicial review is the cornerstone of constitutionalism. Constitutionalism हमने lecture 1 में discuss किया. Judicial review is the cornerstone of constitutionalism. Now there are two kinds of views on the constitution itself, or reading or interpreting the constitution, that is liberal view or literal view. अब liberal और literal के बीच में देखते हैं कि क्या फर्क है. Now the question is, do courts make law or do they only declare law? Right. So the old orthodox theory is that they're only declaring law, they're not making any new laws. But thanks to law being law's creative function, it's a well-recognized fact now that judges do also make law. Now the literal interpretation is very Austinian in nature, that is literal आपके, that we are only declaring laws. Liberal is that with changing times, judge sahab will get in laws like right to privacy, right to information. आपके they all given under 21, are they not? Right to safety, मतलब it's quite a lot. आपके जैसे ज्ञान कौर वाले केस में हुआ था कि no, that you don't have a right to die under 21. And then आपके common cause वाले केस में हुआ था that you have a right to die with dignity. All right, so judges are creating laws. Right to privacy has been given as a fundamental right under 21, right? So you have to balance, the Supreme Court has to balance the public interest versus the individual interest, and same court has to basically go in for passive judicial activism and active judicial activism, wherein if the government is functioning fine, then why do you need to interfere in the function of the executive? Therefore, a purposive rather than strict literal approach should be adopted, because अगर आप strictly literal approach से जाएंगे, then you will only just read the word and that's it. So you'll be always at the whim and fancy of the government. So by the changing times, you have to approach a liberal approach. You have to basically change your approach to a more liberal approach, ताकि आप खुले दिमाग से सोच सकें कि भाई अब आज की डेट में, पहले तो इंटरनेट नहीं था when this constitution was written way back in the 46 to 49 time frame when the Constituent Assembly sat down, right? तो इंटरनेट नहीं था, but आज तो है. What about your internet rights? Stuff such as that. So right to internet, is it a fundamental right? Right to have internet, stuff such as that. So that is a liberal approach. So use these examples and expand on your answers. Okay, now judicial review in India, part of the basic structure declared in many cases, but primarily Indira Gandhi versus Rajanarayan. Article 13 में दिया हुआ है, 32 and 226. 32 में it's the power of writs, 226 you can approach the court High Court for writs and any other right, violation of any other right. So Part 3 fundamental rights यहाँ पे as usual. The Article 13, law inconsistent with or in derogation of the fundamental rights, all law in the force and territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of the part, shall to the extent of such inconsistency be void. Then why do we need doctrine of eclipse? I'll explain the Bikaji Narayan case law. I'll just put one lecture from YouTube. इसके बाद मैं कोर्स के अंदर लगा रहा हूँ, तो उसमें आप डॉक्ट्रिन ऑफ एक्लिप्स मैंने उसके अंदर समझा रखा है. I don't need to again take up paper etc to explain it to you. Just watch it from there. अब ना लड़ाई यहाँ पे है. This is the term void. Why do we need doctrine of eclipse? ये कह तो रहा है भाई void है, but as per the need of the time, the Supreme Court changed the interpretation of this word void to basically to be in you can say suspension or in hibernation. For example, let us say that any pre-constitutional law is there, right? Any pre-constitutional laws, so law आपकी constitution आ गई. Now पहले क्या कह रहे थे जी, these laws are void as long as they are violating the fundamental right. But thanks to the doctrine of eclipse, let us say ये fundamental rights are overruling them and we make an amendment to these laws. All right. So the Supreme Court is now saying कि ये void नहीं है शब्द, they were just eclipsed and now they will become alive as soon as you correct them and bring them in line with the fundamental rights. That's pretty much the doctrine of eclipse. I've explained it in the next lecture. So the point that I've included Article 13 here, use this article in your answer and explain the word void with interpretation of this constitution, that how we have changed the words interpretation to suit our needs. All right. Now, how does all this work is basically on a case-to-case basis. Now we move on आगे. So now how do we basically, what influences interpretation is policy considerations. Well, what is the government trying to do? The Constituent Assembly debates, you can resort to them, that what was the intent of the original constitution writers while writing down a particular provision. So how do we interpret it? Supreme Court can resort to these mechanisms. Preamble, well, what is the will of the people? You can always fall back on the preamble. And आपके, you cannot go into the spirit of the constitution while going in for judicial review. You have to go in for the written text and what is saying कि भाई क्या हो रहा है यहाँ पे, लिखा क्या हुआ है. And foreign precedents only have persuasive value. So whatever is happening in the United States of America or any other international law, that only has a persuasive value. It does not have any, you can say, binding effect unless and until we are a party to that statute and उस case के अंदर. That's a separate story. International law में आपने देख लिया होगा international law वाले second course में, right? Then we go to principle of harmonious construction. तो जब judicial review लिखेंगे तब Marbury versus Madison लिखेंगे, right? Article 13 लिखेंगे, 32 लिखेंगे, 226 लिखेंगे, वो जो लाइनें लिखेंगे कि how is the Supreme Court interpreting it, what are the factors that the Supreme Court can basically fall back on to interpret the constitution. Doctrine of eclipse जरूर mention करनी, because it's the classic case of interpretation of the constitution. Then we go to principle of harmonious construction, that the Supreme Court has to give effect to all the constitution's parts. So you have to interpret them so that one part is not in conflict with the other. Classic cases DPSP versus fundamental rights. All right, so you have to reconcile the parts because many things in the constitution don't make any much sense because they're contradicting each other. So you have to basically read them together. All right. So Article 13 and basically आपका, like for example 368, is the word law defined in Article 13? Does it contain a constitutional amendment as per Article 368? So we have to use that for doctrine of harmonious construction. We are going to get into this debate in the next lecture. All right. Now Shankari Prasad se basically, Shankari Prasad took one view, Golaknath reversed it, and then Keshavanand Bharati took basically the original view. So Shankari Prasad took the view that it is law. Keshavanand Bharati said yes, it is law. Golaknath said no, it is not law. How can they violate? How can they amend fundamental rights? That's what the story is. We're going to come back to this very soon. All right. Now prospective overruling. तो तीन अपने चीजें अगर mention कर दी अपने आंसर में, doctrine of eclipse, harmonious construction, prospective overruling. Usually judges do not make law, but they discover or find law. And it's basically a मुसीबत ये है कि if you find law now today, what happens to the laws that you have already declared पहले, right? All of your judgments. So Golaknath, this case or this doctrine was enunciated, but Golaknath के अंदर यही हो रहा था कि भाई अब इतना हम कह रहे हैं कि fundamental rights cannot be amended at all. Golaknath में हमने ये कह दिया, तो दे सेड अब जो हो गया सो हो गया गोलकनाथ में. दे सेड कि अभी इससे पहले जो सारी जो कहानी थी, let us not disturb those past considerations. Let it be. So this is the doctrine of prospective overruling कि ये judgment will not affect the past, will only be in effect for the future, right? अब जो हो गया सो हो गया, right? So this is basically आपके यहाँ पे now constitutional amendments with respect to fundamental rights, they were already ruled valid in Shankari Prasad, Sajjan Singh, and from the commencement of the constitution till the date of Golaknath, and all enactments, if we follow Golaknath, will it will lead to a lot of chaos, because up till now in Shankari Prasad, Sajjan Singh, etc., we were saying, constitutional amendments, they can amend fundamental rights, and Golaknath said no, they cannot. What happens to all the development of law that we have done for so long? तो फिर तो मुसीबत हो जाएगी ना. So that is the doctrine of prospective overruling, that it comes in effect आगे को. All right. So mention these three doctrines in your answer for interpretation of this constitution. So past may be preserved and future has to be protected. So past में जो हो गया, preserve it and protect the future. All right. Now same case happened in the Mandal case, that is the Indra Sahni case, in which we said कि this judgment, let it take effect after 5 years. All right, because it overturned the general manager versus Rangachari judgment, and 1962 में जो judgment आई हुई थी, it reversed, the Supreme Court reversed the position in 1992 and well said there has to be 50% reservation limit. And now you're like, अरे भाई इतने साल से जो सारा काम किया, इतने सारे जो promotions दिए, इतना सारा सब कुछ किया, उसका क्या करें? तो it is 5 साल बाद ये judgment allow करना. So that is basically now we are suiting the interpretation to ourselves, to basically to the situation as how it emerges. Now, is the Supreme Court bound by its own decision? No, the Supreme Court is not bound by its own decision. This was declared in Bengal Immunity Company versus State of Bihar. So the doctrine of state decisis is given in Article 141, right, where the Supreme Court decisions are binding upon all other courts. Is the Supreme Court included in that list? No. The Supreme Court can overturn its own judgments and take a completely different route from the law already declared. This was declared in Bengal Immunity Company versus State of Bihar. Right, the Supreme Court possessed the freedom to depart from its earlier decisions. 141 always mentioned 141 to be doctrine of stare decisis, and it was held that Supreme Court is not bound, and the Supreme Court is very dynamic, basically, with respect to interpretation and not static. All right, like for example, the Puttaswamy judgment overturned the ADM Jabalpur judgment, right? It said it's bad law. So the Supreme Court can depart from its original stated position depending on the time, basically time of the society, etc. All right, and that's a good answer on interpretation. So ये 3-4 doctrines आपको mention करनी ही करनी है, no matter what happens, right? Next we go to the amendability of the constitution, कि कितनी amend कर सकते हैं, कितनी नहीं कर सकते. So we'll go into the story, the entire case law story up till Keshavanand Bharati using 368 and 13. वही सारी लड़ाई चल रही थी वहाँ पे. तो जरा देखते हैं, अगले लेक्चर में देख लेते हैं उसको, और इस अगले लेक्चर से पहले I'll just put in Article 13 as well. Alright, see you on this one. Take care, bye.